All right, so the last time we were here, state you were to provide discovery on all cases.
I believe that has been done, Judge, and we have tendered an offer of defense.
Yes, Judge. There was an issue of a sealed case and what was going to happen. There was a lot to this case, Judge. We finally got through all the muck. First offer has been made. I'm asking for a reset to confer that with my client, and then we'll make a decision on the next.
All right, how old are you?
Sorry,
How old are you?
25.
All right, Ms. Ferguson, set this in 3 weeks for a plea deadline date, please.
February 19th.
All right, once you sign the reset form, you're excused. At that time, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not, your next setting will be a jury trial date. All right, if you all could get an acknowledgement of discovery for me done?
Sure.
All right, thank you.
Thank you, Judge.
Thank you.
One week,
Yes.
All right, thank you.
Yeah, really good.
He took it. That's the first one. That's well. That's a better thing I've done. I really should know.
Courtroom drama already brewing. Notice how the judge immediately sets the tone. This isn't just paperwork, this is the prelude to serious decisions that could change someone's life. Keep an eye on how plea deals and discovery timing play a huge role here.
I don't like it.
All right, Martin Mendez. This is still contested, is that correct?
I don't believe so, Judge. They agreed to the offer.
Okay, can I have the original motion to revoke on this? I just have the First Amendment.
Yeah.
All right, the court is calling 2019 CR 13071, State versus Martin Mendez. Can I have parties announce?
Lauren Espinoza for the state.
Rafael Leal for Mr. Mendez.
And are you Mr. Mendez?
Yes.
We have an interpreter here today. If you could raise your right hand for me, please. Do you solemnly swear? Thank you. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right, Mr. Mendez, I'm going to ask you a few questions because I've been informed by both parties that this is no longer a contested hearing. Is that correct, State and Defense?
Yes, Judge.
It is my belief, so Judge.
All right, Mr. Mendez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, so you'll have to wait till the interpreter finishes interpreting. Understand?
Yeah. Yes.
All right. When you were here for this case previously on a motion to revoke, you entered a plea of not true to all of the allegations. Do you recall that?
Yes.
It is the court's understanding that you wish to change your plea from not true to true. Is that correct?
Yes.
All right. Did you review the motion to revoke community supervision and the First Amendment motion to revoke community supervision with your attorney? Did you understand it?
Through all the muck, that's lawyers speak for mountains of paperwork, disclosures, and yes, sealed cases. Fun fact: a reset like this is installing. It's strategic. It gives the defense time to review the offer and weigh options, which could be crucial if a plea deal is on the table.
Yes.
And counsel, have you had a chance to speak with your client about changing his plea from not true to true?
Yes, Your Honor.
All right. And I know we put this on the record previously, but for this time, Mr. Leal, do you speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to confer with your client in Spanish?
Yes, Your Honor.
All right. Mr. Mendez, are you the same Martin Mendez who was placed on community supervision in 2019 CR 13071 for the offense of driving while intoxicated third or more on January 13, 2021 for a term of 4 years? Is that you?
Yes.
All right, state you may proceed.
Violated condition number 5 in Bexar County, Texas. The defendant, Martin Mendez, did then and there fail to report to the supervision officer as directed for the months of November and December 2024 in violation of condition number 5.
How do you plead to that, true or not true?
True.
Violated condition number 9A on or about the 18th day of November 2024 in Bexar County, Texas. The defendant, Martin Mendez, failed to report a change of address to the supervision officer within 48 hours in violation of condition number 9A.
How do you plead to that, true or not true?
True.
Violated condition number 40 on or about the 14th day of October 2024 in Bexar County, Texas. The defendant, Martin Mendez, did then and there fail to report to the supervision officer as directed immediately upon release from custody in violation of condition number 40.
How do you plead to that, true or not true?
It is true.
State,
Your Honor, we're asking that
are you waiving the other violation?
yes, Judge.
Any objection?
No objection.
All right, did you understand by pleading true to violations 5, 9A, and 40, the court could find it true, grant the motion, revoke, and sentence you up to 3
Race where it gets serious. By pleading true to these violations, Mendez is effectively admitting he broke the rules of his supervision. The court now has the authority to revoke his probation, which could mean prison time. It's a tense moment because the outcome isn't just paperwork, it's a potential life sentence up to 3 years.
3 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violations 5, 9A, and 40? Court will
Yes.
find 5, 9A, and 40 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion and sentence to 3 years in the prison, as well as take into consideration cause number 2025 CC 016349. That's awesome.
And is that what defense, are you in agreement with that?
Yes, Your Honor.
Mr. Mendez, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, the court will follow your agreement. The court will grant the motion, revoke, sentence you to 3 years in the prison, give you credit for any time served. There's a 2-year license suspension. And the court will take in consideration 2025 CC 016349. There's $1,000 fine, which is a part of your original plea bargain agreement. Time and money will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because you've entered into a plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction.
Boom agreement reached. The judge sentences Mendez to 3 years plus a license suspension and finds this is why plea negotiations are like chess. Sometimes admitting certain things can actually limit the overall damage. Audience question: if you were Mendez, would you take the deal or risk a full trial?
You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, and I'll recommend the therapeutic community as well. Therapeutic community doesn't increase the time that you're in custody. It's a program to help you with any addictions you may have. However, I do not have the jurisdiction to order them to place you in the program. You will still need to request placement in the program. Do you understand? All right, we can go off the record. You're going to have to make better choices when you're released from prison. If you can't find a place that will help you with your sobriety, if I'm still here, come here. I'll pick up the phone and call somebody to help you. All right, good luck to you.
Thank you, Judge.
You're welcome. And counsel, you'll need to take that dismissal to whatever court it's in.
Yes, I understand the procedure, Judge.
All right, thank you. Bye-bye, have a good one.
Thank you.
Try to bring them both for you.
I go to another report. I don't think. Okay. Thank you. I love my. Okay, we'll stay. On page 8.
Thank you. Who's next?
Next, we have on page 5, second from the bottom, Jonathan Lardis.
By the prosecutor, the discovery acknowledgement is 56 pages long. See if we can get a clip.
Jonathan Luzardo. Good morning. Just give me a moment. Odyssey is being a little fickle today. All right. So the last time we were here, it's my understanding that all discovery was received. Is there anything outstanding on discovery?
Yes, Judge, I reviewed all the discovery that was given to me in court that day. There are a number of items that are not included, although referenced by the detective in this case. I've conferred with the state. She's reached out to the detective, I believe, who will be coming in quite soon to gather the rest of that remaining discovery. I can go through that in detail if you need me to, Judge, but there's a number of things that are still absent. I've also gotten an offer from the state today, so I would just request another time for us to review that additional discovery. We'll sign off on it, and then I can confer with my client before we put it on my trial docket, Judge.
All right. So the additional discovery, is that something you have in your possession or?
Your Honor, the only thing that would be outstanding that I need to call and check on would be lab work.
Okay.
Other than that, everything else, it seems like the detective may have in their possession, and they just need to get it to me. It's very voluminous. It's cell phone extractions, Chromebook extraction, Instagram accounts.
So when you say lab work,
Notice how the judge mentions the therapeutic community. This is optional help for addictions. Courts can recommend rehab programs, but they can't always force placement. It is a reminder that some parts of the system are advisory, not mandatory, and the defendant must take initiative.
you're talking about the extractions.
No.
Oh, that's
lab
in
work.
addition to?
Yes, Your Honor.
So lab work and then extractions.
Yes, Your Honor. The extractions have already been completed.
Mhm.
I just need to get them
Okay.
and download them and upload them.
Okay.
Should be quite a bit of material, Judge, so I just would request some sufficient time to go through that.
Okay. So, because I'm just trying to be clear, so I'll know how much time to give you. So the lab work, you're waiting to get that from somewhere else,
Yes, Your Honor.
but it's complete, but you just need to get it.
That's what I need to find out.
So we don't know if it's complete or not.
Not at the moment, Your Honor. I did make a phone call. I was not able to reach anybody at the lab at the moment.
Okay. Let me just put this in the system. Third party. Now the extractions, they are complete. You just need to get them in the format to have him view.
Yes, Your Honor. And I do apologize. I'm looking at my list here, Your Honor. It does look like I need to, based on a conversation with the witness, we need to order CHOSA and child safe records, which I believe would take 30 days.
Okay. So how much time are you all asking for?
Reasonably, Your Honor, I believe 45 days would be enough for us to get everything and get it over to defense and then have a little bit of time to review it, at least to discuss the offer with his client.
Sounds reasonable to me, Judge.
All right, so this is what I'm going to do. This is going to be your plea deadline date. And if for some reason you don't have the discovery in before this date, you all going to need to talk to the coordinator, come back in before this date.
Yes, Judge.
Ms. Ferguson?
Yes.
Give me a 60-day reset. That's going to be your plea deadline
Thank you,
date.
Judge.
You're welcome.
Yeah, March 30th.
March 30th?
Yes, Your Honor.
All right, we'll see you all back at March 30th. Once you sign the reset form, you're excused.
Thank you.
Thank you.
And just like that, another reset is scheduled. These deadlines aren't arbitrary. They ensure both sides have time to review evidence and negotiate effectively. For viewers, it's a peek behind the scenes at how meticulous the pre-trial process really is. Think of it as a strategic pause before the next act in this legal drama.